All right, good morning, students. I hope all of you are doing well. In today's lecture, we'll be covering few general exceptions. Okay, so to begin with, we'll start with the topic of insanity or an act of insane person. Thereafter, we'll be discussing drunkenness or act of intoxicated person. Okay. I hope all of you have been able to download your handouts from the student portal. Just a quick audio check. Can you hear my voice clearly? Are you all able to hear my voice clearly? Right. So when it comes to this topic of insanity or the act of an insane person, legal insanity is defined very differently and specifically when it comes to Indian Penal Code. Okay. And for the application of this defense or the availability of this defense successfully in a trial case, you need to prove all the ingredients of Section 84. So there is a difference between legal insanity and medical insanity. It might be possible that according to the certificates of certain medical organizations, a person is medically insane. Okay, whatever be the diagnosis according to that organization. However, till that time that person fulfills the ingredients of Section 84, that person will not be able to get the defense of insanity under the Indian Penal Code. Okay, so this is one thing that you need to keep in mind before you start preparing this topic, because you need to accordingly focus on the keywords of each of these ingredients. You need to accordingly understand the difference between legal insanity as is depicted under Section 84 and the guidelines laid down by landmark judgments. Okay, so you have to differentiate between that concept of legal insanity and medical insanity. So as a lawyer or as a student of law, you are expected to know the difference between the two, so that even, let's say, in a day-to-day conversation, you come across someone, talking about how insanity can be a defense and what would be their arguments. They would be basing their arguments based on their common sense, their understanding of how the defense should work. But you, as a student of law, would be expected to base your arguments on these ingredients of Section 84. Okay. And from an exam point of view, this topic is extremely important. It has been asked multiple times in the previous year's papers. So if you try and make a list of important sub-themes from this chapter of general exceptions, so in all these sub-themes, insanity would appear somewhere on the top, okay, in terms of the number of times the questions have been asked from this topic. Okay, so accordingly, we'll try and prepare this topic in good amount of detail. We'll also prepare an answer framework on this topic so that by the end of it, you are able to not just understand and have conceptual clarity about this topic, but you would also know that out of all these important pointers that we will be dealing with today, how much of it is actually relevant for writing in your answers. Okay, so for that purpose, we will be preparing an answer framework towards the end of the lecture. So this was about insanity. Thereafter, we'll be moving to this topic of drunkenness. Okay, so drunkenness or the act of an intoxicated person has been dealt in Section 85 and 86. This is again a very important general exception. It has not been asked as frequently as, let's say, insanity, but nevertheless, the topic is important because, yes, it has been asked at least 3 to 4 times in previous year's papers. When it comes to this chapter of general exceptions, you would require specific answer frameworks on each of the general exceptions, because ultimately it's not that you will be asked a general question, okay, or a common question for all the general exceptions. You would be asked a specific question on just one of the general exceptions. So for that specific question, which is going to be asked, let's say as a 10 marker, 15 marker, 20 marker, you need to be prepared with adequate content so that you are able to build your answer on those pointers. Okay, so take each of these sub themes seriously. Okay, and it's not just enough. I always tell students, it's not just enough to understand the topic. You also have to pay attention to how to consolidate all the relevant points of that topic in the form of answer framework. Okay, so having said that, let's quickly proceed to the discussion on the first general exception for today, that is insanity or act of an insane person. So what is the common logic? What do we know? What do we know about this chapter of general exceptions? Common logic of why such kind of circumstances or instances have been given as a valid defense under law of crimes. For that, we need to go back to the first chapter where we knew that there are certain essentials of a crime. Okay, so there needs to be a mens rea, there also needs to be an actus reus. So actus reus on its own is not sufficient. It needs to be supported with a mens rea, that is a guilty mind. So here, when you're talking specifically about insanity, okay, an insane person cannot have the requisite mens rea to commit that particular wrongful act. So that is the basic logic behind giving protection to an insane person under law of crimes. Okay, so the requirement of actus reus might have been completed, okay, in a given set of facts, that yes, certain wrongful act was committed by this accused, but that wrongful act was not supported by the relevant mens rea or the requisite mens rea for that offense, because this insane person is incapable of having that kind of mens rea, right? So that is the main logic behind the defense of insanity. If you don't remember anything else, this is one line good introduction for your answer on insanity. Okay, so it's not something which you have to separately prepare. Okay, you have to always go back to your basics of chapter 1, okay, where you know that mens rea as well as actus reus needs to be present in a crime, and therefore every general exception, okay, you can start your introduction of that answer with this line that yes, there can be no requisite mens rea in such and such instance, and that is why it's a protection. Okay, that is why it's a defense under law of crimes. All right, so keep this general tip in mind, that this kind of approach can be used not just for the topic of insanity, but also for other general exceptions as well. So yes, it gives criminal law gives complete protection to an insane person. Indian law of insanity is laid down under Indian law of insanity is laid down under section 84 of the IPC. What does it say? Nothing is an offense which is done by a person who, okay, so this person is basically the accused, okay, who must have committed that wrongful act and is now being tried before the court. So this person, okay, would not be said to have committed an offense, okay, if that person at the time of doing that act or that wrongful act, by reason of unsoundness of mind. Okay, so the words used in section 84 are unsoundness of mind, is incapable of knowing the nature of his act, or that he is doing what is either wrong or contrary to law. Okay, so he does not know what he is doing. He does not know the nature of his act. He is incapable of knowing the nature of his act or what he is doing, whether it is right or wrong, or is it contrary to law or acceptable to law. Okay, So no person can be convicted of an offense which he committed due to insanity. Again, if you read section 84 in your very first reading, you might feel that you have understood the topic and you will be able to write it in your own words. It's fine, but you also need to understand that there are different components of this definition. So please identify the different components of this definition. Please mark them out, and whenever you are preparing your answer framework, make sure that these keywords are written specifically so that whatever definition you write of insanity in your answers, it is as close as possible to the definition provided under section 84. Okay. Now there is some kind of jurisprudential basis, okay, behind every legal provision. So here we can base that jurisprudential logic or rationale on the two maxims. Furiosus furor sub punitor, that is, a madman is punished by his madness itself, okay, or only. And then furiosus nulle voluntas est, that is, a madman is like one who is absent. Fine. So if possible, try and remember the Latin maxims as it is. They're not very lengthy, okay, very short maxims. Both of them can be included in your answers. They will automatically add a lot of value to your answer. Okay, so from the point of value addition, writing maxims in their Latin version is always better appreciated by the examiner. So if you can, then please try and remember them. Otherwise, okay, you have to at least write the English translation. Okay, so try and remember both these points. They're very important for any answer on insanity because they address the crucial demand of that answer of, what is the rationale, what is the jurisprudence behind that particular provision. So that aspect has to be covered in every answer. And for this topic, this can serve as very good points for addressing that jurisprudential aspect. Okay, so what does it say? A madman is punished by his madness only. Okay, so why is the law of crimes trying to punish a madman when a madman is already punished by his madness? He does not know what he is doing. He does not know what will be the consequences of his acts. Okay, he might not intend to do any wrongful act, but still end up bearing the consequences. Okay, so he's already punished by his madness. Fine. Similarly, a madman is like one who is absent. Again, this is something which you can try and explain in your own words. You don't necessarily have to prepare something separately to explain these English terms. Okay, rather you can just try and write one line of explanation in your own words. So for example, in this case, a madman is like one who is absent. You can just say that, yes, this person who is insane, okay, he does not have the requisite mind. Okay, so forget about having a guilty mind. He does not have a mind itself, okay, to actually form some kind of opinion or some kind of idea, some kind of knowledge about the nature of what he's doing, okay, or he's about to do. Okay, so it's as if he was not present there at all. Okay, so if he would have been present there, then from a reasonable man's point of view, what would we do? We would expect him to act reasonably. Okay, what is the standard? The standard is that of a reasonable and prudent man. So if he would have been a person who was not affected by insanity, then that person would have acted reasonably and prudently. But because of his insanity, we cannot expect such kind of prudence from him or reasonableness from him. It's as if he was not present there at all. Okay, a madman is one who is considered as being absent at all. Okay, absent from that particular set of circumstances. Fine. So the more you think on these lines, okay, how you would want to explain this in your own words in your answer, the more you think on it, the more ideas that will come to your mind. Okay, so there are endless possibilities of explaining these terms in your own words. Please go ahead and do whatever suits your answer writing style the best. Just want to tell you that do not spend one paragraph worth of content on each of the magazines, just one line. One line would be sufficient. A combined explanation for both these magazines would also suffice. Okay. Students, just give me 2 minutes. I'll just be back. All right. So now let's discuss the essential ingredients of this defense of insanity provided under section 84. What is the first essential ingredient? The accused must have been suffering from unsoundness of mind at the time of commission of the offense. Okay, and the burden of proving this lies on the accused. Prior or subsequent insanity is therefore no defense under section 84. Okay, just for checking whether you are able to identify the most important point of these sentences or not, just let me know in the chat box. What do you think is the most important takeaway, okay, from this point? Just in about 3-4 words, let me know what is the most important takeaway of this point. Please reply in the chat box. Okay, students, whenever I ask you to, maybe write something in the chat box or give your responses, please try, okay? Don't hesitate from giving whatever answer you have in mind. It's only through writing or responding in the chat box will you learn. Okay, will you learn that, okay, you might be right, you might be not, but still, at least you will gain confidence going forward that I am able to apply my mind in the right direction. Okay, so yes, some of you have answered, some of you have not. Just for future purposes, please ensure that from next time onwards, try and be more participating, okay? And whatever it is that you are able to understand, okay, whatever answer you think is the correct answer, please make sure you write it in the chat box. So here, the most important takeaway is that this person should have been suffering from insanity or unsoundness of mind at the time of commission of the act. Okay, so prior or subsequent insanity, okay, will be no defense. The accused should be suffering from insanity at the time of commission of the act. And then what are these two words? Prior or subsequent insanity. Okay, prior or subsequent insanity. It does not matter if that person had any history of insanity. It does not matter if that person turns insane after committing the act. Okay, what matters is that at the time of commission of the offense, was he suffering from insanity or not? Okay, so very important point. And again, you can see how through section 84's keywords, we are able to identify that what are those aspects that make legal insanity unique. Okay, legal insanity is going to be different from medical insanity. It is not sufficient that prior to the commission of the act, the person was medically declared insane, or subsequently he is medically declared insane. Okay, he should be suffering from insanity at the time of commission of the offense. And what kind of insanity, that we'll try and understand in the subsequent paragraphs. Okay, so it's not just enough to be certified by a medical practitioner. Okay, there are certain additional requirements. There should be something which the law will ascertain whether or not this qualifies to be called insanity or not. Fine. So this is your first point. Keep this in mind. Then look at these words of Supreme Court. The case over here is not that important. It's just that it's been mentioned here for your satisfaction, but from an answer writing point of view, you would not be required to remember the names of these, of all these cases. There will definitely be some landmark case, so you'll try and remember that and include that in your answer framework, but not this. However, what we need to take away from this is what is the Supreme Court, what is the opinion of the Supreme Court in this regard. So Supreme Court has said that the fact that the person has had an attack of insanity before the occurrence and another one in jail before the opening of the trial does not mean that he committed the offense due to insanity. Okay, so please read this statement again. Okay, so what are we saying? We're saying that it is not, this will not mean that he has committed the offense due to insanity. What will not mean? What would not suffice? Just because he had suffered an attack of insanity before the occurrence, before that particular wrongful act was committed. So at the time of commission of the offense, okay, he might not have been insane. Okay, we're saying that before the occurrence, before the wrongful act was committed, he had an attack of insanity. So this is before or prior. And then another one in jail before the opening of the trial. Okay, so after the wrongful act was committed and before the trial had begun. Okay, so this is again not at the time of commission of the offense, rather it is after the commission of the offense. Okay, so when he was captured and before being produced before the trial court, he suffered another attack of insanity. So both of them, okay, before as well as after, they are not sufficient. Okay, just because he suffered an attack of insanity before and after, that would not be sufficient to give him the defense of insanity. Fine. Then let's come to the second ingredient, that is the accused, because of unsoundness of mind, is unable to know the act that he is doing. Unable to know the act that he is doing. Again, these ingredients have been extracted from the definition of section 84 itself. Okay, no new ingredients have been inserted here. Okay, rather these are the exact keywords that have been mentioned in the provision itself. So you can either try and remember the definition, and from the definition you will be able to list out ingredients, or you can do the reverse also. You can try and remember the ingredients and then you combine the ingredients to form the definition of that particular provision. And the third ingredient, that if the accused knows the nature of the act, then he must not know what he is doing is either wrong or contrary to law. Okay, so just make this correction over here. Okay, in the second ingredient, make this correction that yes, the accused would be getting this defense of unsoundness of mind or insanity if he is unable to know the nature of the act that he is doing. Okay, and then third one is, how is it different from the second one? In the third one, we are saying that let's say the accused knew the nature of the act, but he must not know that what he is doing is either wrong or contrary to law. Okay, so let's take the example of stabbing someone with a knife. Okay, stabbing someone with a knife, or let's call it attacking someone with a knife. Okay, so when you apply that second ingredient to this set of facts of attacking someone with the knife, so we can say that the accused, because of unsoundness of mind, might not know that what is the nature of this act, what is the possible consequence of this particular act. So what will happen if he attacks someone with a knife? Okay, is it going to turn out to be injurious? Is it going to be fatal to the victim? Okay, so the nature of the act will not be, might not be clear to that person who is suffering from unsoundness of mind. So in this second one, we are focusing on the nature, that he does not know what he is doing. Okay, what exactly is it that he is doing? So it can be attacking with a knife, or it can be any other wrongful act. It can be even something that he is simply taking away, okay, and not knowing that if he takes it away, it will be deemed as theft. Okay, so he's just simply taking it away. He does not know the nature of his act, that taking it away would amount to an offense, would amount to the offense of theft. All right, so that is where your second ingredient comes into play. And then in the third situation, if the accused knows the nature of the act, okay, so let's say when it comes to the aspect of attacking with a knife, okay, so maybe he knows that if he attacks attacks the victim with a knife, then the victim would be hurt. Okay, the victim would suffer severe injuries. All right, so he might know the nature of the act, but he might not know that what he is doing is either wrong or contrary to law. So because of the bout of insanity that he is suffering from, okay, because of this unsoundness of mind, he might not know that what he is doing, okay, that attacking the person with a knife, okay, is wrong. He might not know that it is wrong, and he might not know that it is contrary to law. So there are two different situations that have been laid down, and if either of these situations is fulfilled, the defense of insanity will be available. Okay, so the second ingredient over here is more specific. Okay, it's saying that that person did not know the nature of the act itself. And then the third ingredient can be said to be a specific instance of, okay, or let's say an exception to what the second ingredient is trying to provide. So in this third ingredient, we are saying that it is possible, ho sakta hai, that the accused knew the nature of the act. Okay, so he might have known the nature of the act, but still, okay, he would get the defense of insanity. Why? Because this additional requirement, okay, of knowing that what he is doing is either wrong or contrary to law, this additional requirement is getting fulfilled, and that is how he is able to prove the ingredients of section 84. Fine. So the first thing that the accused would want to prove for his defense would be the second ingredient. But if the second ingredient he is not able to fulfill, okay, then he'll try and fulfill the third ingredient. Okay, so first he'll try and show that he did not know the nature of the act. If it is proved that no, he knew the nature of the act, then he will try to show that, okay, he knew the nature of the act, but he did not know that it was wrong or contrary to law. Is this clear? Are these three ingredients clear to all of you? So for any provision, okay, any provision of the Indian Penal Code, the more number of times you read the specific provision, the better clarity you will get. Okay, you yourself will be able to identify the distinct components of that definition and accordingly be able to mark them as separate ingredients. Okay, so in this case, the section 84 definition does not lay down an and or kind of situation. Okay, an and or that all these ingredients need to be fulfilled. Okay, or any of these ingredients can be fulfilled. Rather, the first ingredient no doubt has to be fulfilled in all cases. Okay, that the act should have, the person should have been suffering from insanity at the time of commission of the offense. Okay, so the first ingredient has to be always fulfilled, and then along with the first one, you can either fulfill the second ingredient or you can fulfill the third ingredient. In any of these scenarios, you will get the defense of section 84. All right, clear to all of you? Shall we proceed? Clear to all of you? Please let me know, shall we proceed? Now let's come to this case of Ashiruddin versus King Emperor. So this is a pre-independence pre-independence case. Okay, a case of the colonial era. The facts might not be that important. Okay, you may want to understand the application of the ingredients of this offense to the facts, but you would not find time to write the detailed facts in your answer. Okay, so I just want to tell you from beforehand so that you don't unnecessarily spend a lot of time trying to, put in efforts and, trying to write the exact case facts. Rather, just understand it over here, and if at all you want to use the name of the case to list out what was established in this case, then yes, you can try and remember the name of the case, but the facts need not be written. You can just directly come to the 3 points. Okay, so just go through the facts once. Read the facts. I'll explain it to you in a second. Okay, I'm sure all of you have gone through the facts of this case. So it is clear that in this case, Ashiruddin, okay, or the accused, he would not have normally thrusted a knife in the throat of his son. Okay, he would have not normally killed his son. Okay, his son of 5 years of age. Of course, he must be very dear to him, and he would not have done that under normal circumstances. But he saw a dream. He woke up from the dream, and under this delusion that he had received a divine command, okay, he acted in this insane manner. Okay, and he went ahead and killed his son as a sacrifice. Okay, so he made this sacrifice and he believed it to be right. So in this situation, we can say that yes, he might have been he might have had the knowledge of the nature of his act. Okay, that what he is doing, he is trying to kill his son by thrusting a knife in his throat. So the nature of the act was clear that yes, if I thrust the knife in the throat, then the person will die. Okay, that was the intention. That was what he was trying to do. So he knew the nature of the act, but he did not know that it was wrong. Okay, he believed it to be right. He believed that he's making this sacrifice. Okay, and he was executing the divine command. Okay, what he has seen in his dream, and therefore what he did not know it to be right, even though he might have known the nature of the act. Okay, so he did get the defense of insanity. And what was established in this case, that in order to get the benefit of section 84, okay, it must be proved that the nature of the act was not known to the accused. Then the act was not known by him to be contrary to law, and the act was not known by him to be wrong. Okay, so three different aspects are there. Okay, you please identify these three set of keywords and try and write your answer accordingly. Please ensure that whatever description you are giving of insanity, it should be a complete description. Please do not just leave your description of insanity to the fact of nature of the act. Please go one step ahead and complete the definition by also talking about contrary to law and wrong. Okay. However, this was a very criticized judgment. Okay. And the acquittal of the accused was not convincing. Sir Stephen had also said that if a special divine order was given to a man to commit murder, I should certainly hang him for it unless I got the special divine order not to hang him. Okay, so he was very disturbed by the judgment given in the Ashiruddin case. Okay, however, in those times, okay, in those times, such kind of logic or such kind of divine commands or such kind of encounters were very common, okay, in the society. So you have to understand the logic that was being applied from the times of from the situations that existed at those times. Okay, the circumstances in the society which was considered as a normal occurrence, okay, which was considered as yes, this can be possible, that someone can get this kind of a dream and under the pretext of a divine command he can execute a crime. So do not go into the logic based on what we think in today's times. Okay, but yes, at that time that logic was applied and he did get the defense of insanity. That's why I say that do not go into the facts of that case. Okay, no need of giving the facts. You can definitely give better illustrations in your answer rather than relying on Ashiruddin versus King and Emperor's facts. But however, you would want to write about these 3 points. What was established in that case? Okay, the nature of the act, contrary to law, and wrong. These 3 keywords. Try and remember these keywords and automatically write them under the heading of Ashiruddin versus King Emperor. Fine. Next, we'll come to the difference between legal and medical insanity. The legal concept of insanity differs considerably from the medical conception, and it is not that every form of insanity or madness which is recognized by law is a sufficient excuse. Okay, so when we are saying it's recognized by law, we are saying that yes, something which can be medically termed as insanity and is recognized by law as well. So it's not that everything that is recognized by law is insane would be applicable to a given set of facts. Rather, what would be considered as insane for that particular case, that will depend on the facts and circumstances of that case. Okay, not all the types of insanity or every form of insanity or madness which is recognized by law, okay, it will not be sufficient excuse in all the cases. Okay, I hope you get the gist of it, that this is a very specific defense which requires specific ingredients to be fulfilled, and it will depend upon the facts and circumstances of the case. So what would amount to insanity in one case might not amount to insanity in another case because of the varying sets of facts. All right. So man may be suffering from some form of insanity in the sense in which the term is used by medical men. Okay, so medical men might term that person as suffering from insanity, but may not be suffering from unsoundness of mind as described in section 84. Okay, so we know that legal insanity is different. It is very specific. So a person who has been declared insane by a medical team of practitioners cannot automatically get the defense of insanity under court of law. Okay, he would need to separately prove the ingredients of section 84. So if the facts show that the accused knew that he had done something wrong, it did not matter how, though he might be insane from medical point of view, he could not be exonerated under section 84. Okay, so if we know that the accused should not be in a condition to know that he had done something wrong. Okay, if for whatever reason he knew that what he is doing is wrong, then he cannot be said to be insane under section 84. Okay, he might be insane from the medical point of view, but he would not be considered insane under section 84. So just for the example purpose, okay, so let's just take the example of a person who commits a murder, okay, and he tries to run away from the scene. Okay, so he committed the murder. Okay, he might have committed the murder for whatever reasons, whatever must be his state of mind, but we are trying to look at the effect, we are trying to understand what he did after committing the crime. So after committing the crime, he tried to run away from the scene of crime. So that goes on to show that he knew that what he had done was wrong, and that is why he was trying to save himself. He did not want to get caught. He knew that for what he had done, he will get caught by the police, he will be tried before the court, he would be put to jail. Okay, so he did not want that, and that is why he tried to run away from the scene of crime. So if he knew it to be wrong, if the accused knew that he had done something wrong, then this defense would not be available. Even if, let's say, he had some history of insanity, even if the medical practitioners certify that yes, he had been suffering from insanity, but this defense of insanity under section 84 will not be available to him. All right. So the opinion of medical evidence, however eminent he may be, must not be read as conclusive of the fact of insanity. Okay. So eminent, okay, we are talking about the team of medical practitioners. Okay. So whatever medical evidence has been produced before the court of law, okay, and by whoever, okay, no matter what is the position of that particular medical practitioner, he must be a very eminent doctor, okay, and he must have certified that such and such person suffers from such and such medical and mental problems. Okay, but that is not going to be conclusive of the fact of insanity before a court of law. Okay, the court will apply the ingredients of section 84 to the facts of the case, and only then will it decide on whether to give the defense of insanity to the accused or not. Sir Main has said that in dealing with medical evidence, it must always be remembered that their function is to assist. Function is to assist, not to supersede the judge. So, you know that you can actually get a question in the exam asking you to differentiate between legal insanity and medical insanity. So you need to have different types of keywords or different angles from which you would differentiate between medical insanity and legal insanity. So all this detailed discussion that we are doing here, all of this will give you some specific terminologies. Okay, so please try and identify those specific terminologies and try and incorporate them in your answer framework, so that when you are writing your explanations in the answer, okay, when you are building the main body of your answer, you are not just repeating the same content and the same terms again and again. Rather, you are trying to cover some unique dimension in every new paragraph. Okay, so for example, we have already discussed about legal insanity and medical insanity in so many ways before this statement itself. But still, when you come to this statement, you again come across a different way of explaining. Okay, explaining the difference between medical insanity and legal insanity. Okay, so the medical evidence always has to assist. What is the function of this medical evidence? This function is to assist and not to supersede the judge. Okay, so the judge will follow the legal principles laid down under section 84 to arrive at the judgment. Okay, so whatever mind has to be made up, okay, when the judge will make up his mind based on application of legal principles. Now, in the application of legal principles, he might find the assistance of this medical evidence useful. Okay, so it will help in further proving the case of the accused, okay, or disproving the case of the prosecution. But in either case, it will not supersede the judge. Okay, so it's not just because that the medical evidence is pointing towards insanity, automatically the judge would be compelled to give the defense. No, that is not going to happen. Okay, so the judge will decide on his own, and this medical evidence can never supersede the judge's opinion. Okay, it can only assist. So assist and not supersede. If you just write two of these keywords, you will automatically be able to explain this point in your own words. Do you all agree? Do you agree that yes, you can explain this point in a separate paragraph? It will add a new dimension to your answer. Just that you need to include these keywords in your answer frameworks. Otherwise, you will not know how to write all these unique dimensions in your answer. Fine. So the medical witness states the existence, character, and extent of the mental disease. Okay, existence, character, and extent, ECE. Okay, medical evidence would point towards the existence, character, and extent of the mental disease, ECE of the mental disease. But the judge is to decide whether the disease made out comes within the legal conditions which justify an acquittal on the ground of insanity. Excuse me. So who will decide? It is the judge who will decide. Okay. So look at this case, Brij Kishore Pandey versus State of UP. The accused in a case was examined by 2 doctors before as well as after the occurrence of the offense and was found to be schizophrenic. And his abnormal behavior was apparent from his general activities as well. The court accepted the plea of insanity without hesitation. Now, this kind of schizophrenic activity is what he was doing before as well as after. So this helped in, or you can say assisted, okay, assisted in coming to the conclusion. So this before, after, also this abnormal behavior apparent from his general activities helped the court to decide that yes, at the time of the commission of the offense also, he must be suffering from this same mental disorder, schizophrenia. Okay, and that is how the court accepted the plea of insanity. So you can use this kind of a case to show how it can assist. But ultimately, your last statement in your explanation again has to be this, that the judge will decide. Okay, so the judge decided on the basis of the evidence produced, okay, but the judge decided because the legal requirements of section 84 were being fulfilled. Now look at this test of insanity. This is a very important statement. Look at this. The policy of the law is to control not only the sane but also the insane. You can actually note down the statement as a good introduction for an answer on insanity. Okay, so what is the law trying to do? Law is trying to control not only those who are sane, but it is also going to control those who are insane. Okay, so it is not therefore every mentally diseased person who is ipso facto exempted from criminal responsibility. Right? So just try and understand the logic or the reason why these ingredients of section 84 are being emphasized upon. Okay, why is it that there is a separate test of legal insanity, and why isn't the court just ipso facto accepting the medical evidence to be the test of insanity? Because the law also has to control the insane. So just because a person is mentally diseased or mentally insane, it does not automatically mean that he would always get the defense. Okay, he would get the defense only if at the time of the commission of the crime he was suffering from insanity, and at that time he did not know the nature of the act. If he knew the nature of the act, he did not know whether it was contrary to law or wrong. Okay, so these two lines, look at these. The first line, of course, the policy of law is to control not only the sane but also the insane. And the second line, that it is not that every mentally diseased person who is ipso facto exempted from criminal responsibility. Such exemption is allowed only where the insane person is incapable of knowing the nature of the act, or that what he is doing is either wrong or contrary to law. Okay, so this statement is something which you already would be knowing. Okay, right? You have tried to, identify these keywords of section 84. So I'm sure by now you already have memorized what are these keywords and how you have to explain it. What are these different specific ingredients or requirements of section 84? So the second line, okay, whatever is explained here can be preceded with this kind of content. When you're trying to explain the test of insanity and the logic behind it, the rationale behind it, okay, we're trying to understand the rationale behind it. We are trying to say that law will not just try to control the sane, it also has to control the insane. So just because a person is insane, he will not automatically get the defense always. Okay, he has to prove the ingredients of section 84, only then will he get the defense. Otherwise, the insane person will also be convicted of that offense. Okay. This section lays down the legal test of responsibility in cases of alleged unsoundness of mind. It is by this test, as distinguished from the medical test, that the criminality of an act is to be determined. Okay, just again, I'm not trying to make you identify any further keywords because it's all just another way of writing the same thing. No unique terminologies over here. It's up to you. You can just read it and help. This will help you in understanding, but you do not necessarily need to add this to your answer framework. Wherever we come across any unique terms, we will definitely try and identify and box it out. I'll also try and point it out separately so that you don't miss it. Now look at this. So how do you define legal insanity? For legal insanity to be proved, it must be shown that at the time of committing of the act, the accused was laboring under such a defect of reason from the disease of the mind as not to know the nature and quality of the act, or that he did not know that he was doing what was wrong. In that case, it was shown that the accused had left the place of murder immediately after committing the crime and clearly remembered in a confession given the very next day all that he had done. So he was not entitled to the protection of Section 84. So remember, I gave you the small illustration in one of the previous instances that if you run away from the crime scene, okay, then it is going to prove that you knew the nature of the act. Okay, you knew that what you had done was contrary to law. So therefore, in such situations, you will not get the defense of insanity. So you can try and remember the name of this case, Someshwar Bora versus State of Assam. It is something which, this case has very simple facts, okay, nothing very elaborate, nothing very specific as well. Okay, it's just about, if you try and focus on the keyword of being contrary to law, knowing that it is contrary to law. Okay, so and if you try and think of an illustration, I think this is the first illustration which will come to your mind, that we can prove that the accused knew what he was doing was contrary to law if he tries to abscond, okay, if he tries to run away from the scene of crime. Okay, so the set of facts are pretty straightforward and simple. You can try and remember the name of the case and then explain how it will be shown that he knew that it was contrary to law using the facts of this case. Fine. So there are certain terms here, some new terms which can be used, but again, if you feel that you already have a repository of terms and you do not need anything more, it's fine. It's completely fine to be able to focus on the main keywords. If at all you want some extra keywords, look at this, okay? Laboring under such a defect of reason from the disease of the mind. So because of that disease, okay, because of that mental disease that he is suffering from, he was laboring under a defect of reason. Okay, he could not apply his reason, okay, and he would not be he did not know the nature of the act or nature and quality of the act. Okay, so this set of facts can be used in your explanation. Pretty straightforward, simple set of facts. Someshwar Bora versus State of Assam. Now this is again a new dimension. Please make sure that you are able to use this separate dimension in your answer. So we are saying that, of course, what is the most crucial point? The crucial point is the time when the offense was committed. Okay, so if you want to ascertain the state of mind of the accused, then you have to see what was the state of mind at the time when the offense was committed. And for that, okay, or that can only be established from the circumstances which preceded, attended, and followed. Okay, so preceded, attended, and followed. Again, these are some important keywords which you would want to include in your answer framework. PAF, preceded, attended, and followed the crime. How would you ascertain what was the state of mind of the accused at the time of commission of the crime? By looking at the circumstances which preceded, attended, and followed. So preceded is basically the circumstances before the act of crime, okay, or before the wrongful act was committed. Attended means at the time, and then followed means after the wrongful act was committed. PAF. Please try and remember this. This is again another illustration, Sanna Irana versus State of Karnataka. In this, what had happened was, okay, this was an instance where the person, for no apparent motive, killed his own kith and kin. Towards him, he had all along been affectionate. Okay, and where the person also had a previous history of lunacy. So he had a history of lunacy. Okay, he was all along affectionate towards the victim. Okay, that victim was his own kith and kin. Okay, and without any specific motive, without any apparent motive, if that person kills his own kith and kin, okay, he had been affectionate, so he had showed that he can be affectionate towards that person, and then he also had a previous history of lunacy. So all these circumstances go on to prove that yes, he should be entitled to the protection given by Section 84. Okay. Now, when we talk about landmark judgments related to the topic of insanity, this case of McNaughton, okay, this McNaughton's case is the landmark case for the provision of, or for the defense of Section 84. Okay, so let's just understand the legal doctrine that was laid down in McNaughton's case. So it will be seen that a lunatic is rightly protected by law. If he commits any offense, naturally he cannot be held liable because the person does not know what he is doing. Mens rea is entirely absent in his case. If he commits murder, it is a case of pure misfortune or accident, so far as the victim is concerned. Okay, so mens rea will be absent. Actus reus was definitely present. He went ahead and committed that wrongful act. But that actus reus was not supported by the requisite mens rea. Okay, this mens rea was entirely absent, and that is why he should not be punished. He should get the defense. So the legal doctrine in regard to criminal insanity was for the first time settled in England in the McNaughton's case, also referred to as McNaughton's case. Okay, the facts of the case are as follows. Please read this entire set of facts. Okay, facts are pretty simple. Facts just give you a background. Now, what is most important to be remembered about this case are the McNaughton's rules that were laid down in this case. Okay, so let's look at these McNaughton's rules. Every man is presumed to be sane and to possess a sufficient degree of reason to be responsible for his crimes until the contrary be proved to the satisfaction of a jury. Okay, so the first point is related to the presumption of sanity. Okay, so every man will be presumed to be sane. So along with that presumption, what all it comes? What all comes along with this presumption of insanity? The presumption that the person was expected by law to be acting in a reasonable manner, was expected by law to be aware of the legal consequences of his acts and omissions. Okay, therefore, a person who has been presumed to be sane under law would be punished for the crimes that he has committed. Okay, so this presumption of insanity, this is a very important keyword. Please make sure that you make a note of it. And to possess a sufficient degree of reason to be responsible for his crimes until the contrary be proved to the satisfaction of a jury. Okay, so he would be held responsible. So he would be presumed to be knowing the legal consequences of his act, and therefore he would be held responsible for his crimes until the contrary be proved. So what is contrary to this? Okay, what is contrary to the presumption of sanity? The contrary would be that yes, if it is proved before the court of law that in fact he was okay. So these keywords that have been used in the second point are the same as what are mentioned under section 84 of IPC. Third, as to his knowledge of the wrongfulness of the act, the judges said, if the accused was conscious that the act was one which he ought not to do, okay, he ought not to do, he should not have done it, okay, if he is conscious about it, and if that act was at the same time contrary to the law of the land, he is punishable. He is punishable. Fourth point, where a person under an insane delusion as to the existing facts commits an offense in consequence thereof, criminality must depend on the nature of the delusion. If he labors under partial delusion only and is not in other respects insane, he must be considered in the same situation as to the responsibility as if the facts with respect to which the delusion exists were real. Okay, so please read this particular statement again. It says that whenever there is an act of criminality, a wrongful act which has been committed under an insane delusion. Okay, so the criminality will depend on the nature of the delusion. And when you're trying to understand the nature of the delusion, okay, then if he's suffering from partial delusion only, okay, and is not in other respects insane, means for some things he is imagining that he's delusional about those things, and then for others he is not delusional. Okay, so he will not be deemed to be insane in those respects. He must be considered in the same situation as to the responsibility in the sense responsibility for his wrongful acts. Okay, we're trying to hold him responsible for his wrongful acts. Therefore, he'll be considered in the same situation as to responsibility as if the acts with respect to which the delusion exists were real. Okay, so whatever the delusion is about, okay, let's say that whatever, be it a partial delusion, okay, whatever is the delusion about, what part of the facts was he delusional about, let's consider that yes, he, in fact, those that delusional set of facts was real. Okay, so that partial delusional set of facts were real, and then the rest of it he anyway thought to be real. Okay, now imagining all these facts in combination, okay, then we will try and ascertain his responsibility. Okay, so knowing what was real, also considering what he was delusional about as real. Okay, so all this in combination, okay, I try and ascertain the responsibility of the person related to that crime with respect to such set of facts. And if he still proves, if he still is able to fulfill the ingredients of section 84, okay, or fulfill the requirements of insanity, he will get the defense of insanity. If he is not able to do so, he will not get the defense of insanity. Okay, so in addition to above, it was also said in the McNaughton case that a medical witness who has not seen the accused before trial should not be asked to give his opinion as to the state of prisoner's mind. So we had said that medical evidence can assist, okay, but medical evidence also has to be laid down with, also has to be accepted with certain rules. Okay, it's not that every type of medical evidence would be considered before the court of law. So one of the rules that have been laid down here is that medical witness, medical, practitioner, the practitioner who is certifying that the accused is insane or not. So that medical witness, if he had not seen the accused before the trial, okay, so if he had never seen the accused before the trial, if he had not examined the accused even once before the trial, then he should not be asked to give his opinion as to the state of prisoner's mind. Okay, so he did not have any history, he did not have any knowledge about the history of the accused. Okay, and subsequent to the wrongful act having been committed, and now at the stage of trial, there is no point in asking that medical witness to give his opinion. After the above rules were promulgated, the courts have adopted the rule that where insanity is pleaded, the onus of proof of insanity lies on the defense. Defense being the accused. Okay, so the onus or the burden of proof will always lie on the accused. And where it is not pleaded, the accused shall be acquitted if the evidence before the court does establish insanity within the McNaughton rules. Okay, so let's say there is a case where he has not pleaded the defense of insanity. Okay, even if he has not pleaded the defense of insanity, still if the evidence before the court establishes insanity, he would get the benefit of that defense. Okay, he would be acquitted. Okay, so these are certain rules related to evidence. However, it will help in value addition to your answer. So please make sure that you are able to include these points as well. That the burden of proof is lying on the accused, okay, or on the defense. However, if the accused or the defense has not pleaded insanity, but the court deems it fit that all the requirements of Section 84 are being met here, then the court on its own can also acquit the accused. Okay, the court can give this defense of insanity. These rules are still received in the courts as the binding authority on the defense of insanity. Okay, so very important case law. The facts are not that important. Please do not try and enumerate the facts of McNaughton case in your answer. It will unnecessarily get lengthy and it will not add much value to your answer anyway. Okay, so rather spend that much time and effort on enumerating the different rules laid down in the McNaughton case. And if you're able to do that exhaustively, that is going to be way more beneficial in terms of being, in terms of making your answer multidimensional, in terms of getting extra marks for exhaustive coverage of the topic in your answer. Okay. Thereafter, you can see that there are certain specific instances of insane delusion and delirium tremens. Now, please go through these types of specific instances of insanity. You will not be asked a separate question on any of these. However, it's always helpful if you can write one paragraph worth of content on these subtopics in your answer on insanity. So whatever is the type of question that has been asked, okay, so it can be a straightforward question to explain the ingredients of Section 84. It can be a statement-based question on Section 84. Okay, so all in all, you know that there are these important pointers that need to go into your answer. There are these important pointers that need to go into your answer, and each of these pointers would be required in all the answers of insanity. So be it a straightforward question, be it a statement-based question, your framework would more or less remain the same. Okay, so try and prepare that framework, keeping in mind that you would want to write such and such pointers for a 15 marker. How would you expand on certain extra thing when it's a 20 marker? What all will you cut short, okay, or cover in very concise manner when it comes to a 10 marker? Okay, so make your framework imagining that it's a 15 marker question, and then accordingly kind of work your mind around it, that how would you expand it, expand on certain topics to write a 20 marker answer, and how would you make it a 10 marker answer. Okay, I always tell students that be it a 10 marker question, be it a 20 marker question, okay, your detail of content coverage might vary. Okay, so there can be different level of detail in 20 marker. It can be very less detail in your 10 marker, but the number of dimensions, okay, or the different number of unique points that you're covering in your answer should remain the same as far as possible. Okay, so if you follow this approach, you are ensuring that your answer framework remains the same for all three types of questions. However, you are just working on the amount of detail you would write in the answer. So the same answer framework applies to all three, and you would want to maximize your score in all three questions. And the only way to go about it is that make your answer as multidimensional as possible. Okay, So coming back to this, yes, these two headings of insane delusion and delirium tremens, I'm not covering it in detail in class. Please go through the handout, read it on your own. Don't, again, keep it in mind that there will not be a separate question asked on it, but from an understanding point of view, what is that one paragraph worth of content you would want to write under these headings? Okay, so just prepare that in your answer frameworks as well. Also, this topic of irresistible impulse, the same applies to, the same approach applies to irresistible impulse as well. All right, students, we'll just take a 5 minutes break and then we'll start with the topic of drunkenness.